The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 983, coming to you on Monday, the 14th of September, 2020. On this program, I will speak to you on the topic, the compulsory acquisition of land. But before getting into the topic, a few preliminary comments, beginning as usual with expressions of condolence to all families which have suffered recent bereavements, and in particular the family of the father of our leader of the opposition, Dr. Godwin Friday, Mr. Richards, who passed a few days ago. Our heartfelt condolences go out to the whole family, especially Dr. Friday, who also lost his mother earlier this year. Yesterday there was laid to rest a well-known gentleman in tourism circles in St. Vincent and the Grenadines, Mr. Charlie Grisha, otherwise known popularly as Charlie Tango. His wife was a close friend and prayer partner of my wife, Bishop Campbell. They go back a long time, over 30 years. Indeed, my wife unfortunately had an accident a couple of Friday nights ago, and the first person who reached her bedside at the hospital was none other than Nora, the wife of Charlie Tango. Nora, I thank you for having been there for Mrs. Campbell, and we all are with you and all of the children and all the members of the family. Charlie was laid to rest at sea in accordance with his wishes. And then just today, I was saddened to hear of the passing of one of my god brothers, who was a verger or the verger at St. George's Cathedral for many years. In fact, whenever there would be a procession, he would normally lead the procession dressed in black. He would be sadly missed. He was the godson of my mother, and me and all my siblings send our deepest condolences to the bereaved family. Brother Ulrich Doyle, originally from Barley, but for the last umpteen years he has been living in Kingstown. And when my mother was alive, Ulrich would not pass me anywhere without asking me about Tanti Rosalie. That is what Ulrich called my mother. My deepest condolences to all bereaved persons everywhere in the state. Finally, let me commiserate with the Honorable Prime Minister and the other members of his family on the announced illness of his wife and his son Adam. I heard with shock when the Prime Minister announced last week on radio, I think it was last week Wednesday, on NBC Radio 75, that his wife has an ailment which is serious and that his son also has a serious ailment. Our prayers go out to you, Prime Minister, to all the members of the family. And we know that the Lord is capable of miracles. And let us hope that in your case, miracles will be wrought to restore your wife and son to health. Excuse me. Now for the topic. I had made a decision that with the approach of general elections in this country, I would try to avoid dealing with topics which have or could potentially have a heavy political content. Because I've been involved in politicking in this country since 1972. The only elections I missed was the election in 1974 when I was away at Cave Hill. But I was a campaign manager of Cyril Alexander's election in 1972. I was a candidate myself in 1979. I was at the front of the NDP campaign in 1984. I was a candidate in the by-election in 1987, candidate in general elections in 1989, candidate in general elections in 1994, candidate in general elections in 1998. So I know what elections are like in this country. I know what our people are like. So I said, look, anything political, I would just not make any comment one way or the other until after the elections. But a couple of weeks ago, I got a phone call from a good friend, Mr. O.T. Mayers, asking me to do a program on the acquisition of land by the government. So I said, Brother Oti, I have not been dealing with political topics or topics with a heavy political connotation. And I don't think I would want to dabble with this one because this one has become very highly controversial in recent weeks in St. Vincent and the Grenadines. And perhaps after the elections, I may touch on it. So Oti pleaded with me and he offered to pay for the program. I said, Oti, I don't collect fees to do the law and you. It's a free program. SVG-TV very kindly and generously provide me with the air time and the production time, and they do the production free of cost. So I don't earn any fees from the law and you. So we chatted. I gave him a little joke about underground furniture, and I couldn't resist that. But since then I have thought about it, and I decided to depart from my policy. And in deference to my good friend O.T., to deal with the problem of the acquisition of land by the government. Because of the voluminous nature of the material, I will have to do the program over 2 weeks, 2 programs. So this will be part 1, and hopefully next week, Monday, Divi, I will bring you part 2 of the compulsory acquisition of land. It is a topic with which I am very familiar, because anybody who has served as Attorney General in this country would be very familiar with the principles pertaining to the acquisition of property compulsorily by the government. We have to give advice from time to time to the government. We have to know what the law says so that we could guide the government. And I have been involved in several acquisitions in my time as Attorney General. In fact, even before I became Attorney General, I was involved in an acquisition compulsorily by government of land at Murray's Village, of all places, because the late Eddie Griffith had started acquisition proceedings pertaining to some Nanton lands in Murray's Village, and he died. I took over from him in the constituency, and when I became Attorney General, it was one of the matters I had to finish up. So we dealt with that, and I will have a few more things to say about that one in next week's program. Of course, the most notorious acquisition we've ever had in St. Vincent and the Grenadines was the acquisition of the Orange Hill Estates from the Danes. When Mr. Mitchell campaigned in 1984, he campaigned on the promise mainly of turning St. Vincent and the Grenadines into a property-owning democracy. And one of the things he promised to do was to acquire the large estates, cut up the lands, and hand them out to farmers on leases. That, of course, was a highly controversial acquisition. I'll give you a little joke about that. Not too long after the Prime Minister had won office in July 1984, he approached the family who owned the Orange Hill Estate to negotiate with them for the purchase of the estate, so that the land could be redistributed to the farmers, most of whom had been working those very lands. Well, at the time, the owners had an arrangement with the Danes, whereby they managed to circumvent the provisions of the Aliens Landholding Act and so-called sell Orange Hill Estates to the Danes for a given price. So that one day the Prime Minister Mitchell, called the local attorney for the Orange Hill owning family and said, look, government is now ready to go ahead to purchase the Orange Hill estate. And you know what that lawyer told Prime Minister Mitchell? He says, son, you're too late. We have already disposed of the estate. No, Mr. Mitchell did not take too kindly to that. And when he related to us in caucus, he used some choice language. But he was extremely incensed that a lawyer for private landowners could tell the government they're too late in respect of lands which the government wanted to acquire for the people and on which they had campaigned during an election. So the Prime Minister set about acquiring the land using the legal mechanism, which I will be discussing with you very shortly. And that triggered its own saga. Now, most countries and all democratic countries have legal mechanisms by which the government can compulsorily take over land belonging to anyone on certain conditions. In our case, the law of compulsory acquisition is to be found in two sources mainly: the Constitution of the country and the Land Acquisition Act. The Constitution of St. Vincent and the Grenadines gives the government the right to acquire any private land for a public purpose and in accordance with a law regulating the whole acquisition procedure and the machinery. Excuse me. I have brought along with me, as usual, the relevant legal instruments. Firstly, I want to quote to you from the Constitution of St. Vincent and the Grenadines. Now, if you look at the existing Constitution, Section 6 deals with protection from deprivation of property. And it says, I wouldn't read you all of it, but just, and Section 6 is a long section. It occupies almost 3 pages of the text of the Constitution. It says, Section 6, subsection 1, no property of any description shall be compulsorily taken possession of and no interest in or right over property of any description shall be compulsorily acquired except for a public purpose, and except where provision is made by a law applicable to that taking of possession or acquisition for the payment within a reasonable time of adequate compensation. And Section 6 goes on at length. These provisions are meant to ensure that governments don't take people's property willy-nilly and refuse to pay them for their property. So the Constitution itself has gone to great lengths to say that if the government wants to take any private property, compulsorily, it must have a reason, which is a public purpose for wanting that property, and it must do that in accordance with a law which provides a mechanism for the assessment of compensation and for the payment of that compensation within a reasonable time. Now, let us get this clear. The government, like any private person, can buy any property it wants from a seller and from the owner of the property on a negotiated basis. So there's nothing to stop the government going and buying a piece of property from Mr. X. If Mr. X agrees to sell, a price is agreed and so on. The law is not dealing with voluntary acquisitions. It's not dealing with the sale, the purchase and sale of property. It's dealing with the situation in which the government wants a property. The landowner may or may not want to sell it to the government, but the government wants it for a public purpose. The law says the government can take it for that purpose. But in doing so, the government has to act in accordance with a law which sets out a framework for how compensation is to be assessed and the paying of that compensation. So that is one of the legal instruments we have to be concerned with on the question of compulsory acquisition. The second legal instrument is the Land Acquisition Act. And the existing Land Acquisition Act is to be found in Chapter 322 of the Revised Laws of St. Vincent and Grenadines, 2009. That act has about 32 sections, and that act provides a comprehensive code, a guidance to the authorities as to how acquisition compulsorily should be gone about, what steps have to be taken, and all the proceedings. When we examined the Constitution of this country between the years 2003 and 2008, We, the Constitutional Review Commission, looked at the question of compulsory acquisition very closely. I remember months and months we debated and studied, and because we wanted to make sure that the new constitution would have been an improvement over the existing constitution where compulsory acquisition of land is concerned. In our assessment of the law, we found that there were basically three weaknesses in the existing law. That is, the law which was in force at the time and is still in force up to today. But the bulk of it we were satisfied to leave as it is, as we found it. The three matters that we thought needed addressing was to spell out in a little more detail what is meant by adequate compensation, to remove the provision of the law which says that when you acquire property, the value of the property has to be assessed as what it was 12 months before the acquisition. And thirdly, we didn't like this payment within a reasonable time. We thought that a time limit should be set when the government acquires property for the payment of compensation. So the only changes we had proposed in the new constitution to the existing regime of land acquisition by the state were: one, to elaborate on what is meant by adequate compensation; two, to remove the stipulation that you had to assess the value of the property what it was 12 months before the acquisition, which is still the law now; and three, to make sure we set a time frame on the government. So in the proposed constitution, we had proposed three remedies to what we saw as the three weaknesses in the existing law. Firstly, we propose that the phrase adequate compensation should be expanded, and this is what we propose. Adequate compensation, that is, compensation which in all the circumstances is fair and reasonable to the person entitled to compensation and also to the state. Then we propose the removal of the 12-month stipulation. We said it should be without limitation as to the date at which compensation should be assessed. And thirdly, we want to give the government a time limit within which to pay compensation. We said, provided that compensation shall be paid within 12 months of the date of the compulsory taking possession of our acquisition. Those are what we proposed in the new constitution, but of course the people rejected that. So today, when the government compulsorily acquires any property, the compensation is assessed as to what the property was worth 12 months before the date of acquisition, not what is worth now. And today, there is no set time limit on when the government should pay compensation. which is where you hear about compensation not having been paid for umpteen years for property at Richmond Hill belonging to Mr. De Freitas and so on, because the law doesn't specify a period of time. But had the new constitution been accepted by the government, by the people, the government would have had to pay any acquisition monies, any compensation within 12 months. And that compensation would have been assessed on the value of the property as it was at the time of acquisition. Now, I have looked at all the various instruments passed surrounding the present dispute in Murray's Village. I got the government gazettes. I also got the gazettes from acquisitions years gone by. I have studied them. And when I speak to you next week, Divi, I will give you my conclusion as to whether the attempted acquisition, when I say attempted, I don't mean to say it was not done in accordance with law, but whether the procedures for the acquisition of the Murray's Village property belonging to the MacLean family were done in accordance with the law. Okay? So I hope you, with that background, you would tune in next week, Monday, Divi, for a specific examination of what has taken place with the Murray's Village lands and what is the present position now according to the law of the land. All right, so that is all from this program of The Law and You, program number 983. I look forward to being of further service to you next week, Monday, Divi, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.